completely speaking with me, Tarun Nangia, the sign of any developed society or a society which will be developed in the years to come is how it takes care of not only manufacturing service industry, which is linked to production and income, but also of the environment, because that is a sign of a truly developed society. And the Supreme Court, in the sense, has done a laudable effort by giving a judgment which furthers the cause of environment and development both, where this order, which is this judgment, which is ordered by Justice Dhananjay Chandrachud with Justice Dhananjay Chandrachud, Justice Manoj Mishra, Justice J.B. Pardiwala on the bench, where in an area of almost 1 lakh kilometers, they have said that the electricity transmission lines have to be underground. The details my panel will share, because this is linked to the protection of the environment. How, what, my panel, who are experts on this issue, they will share with you. Let me welcome my panel to you. I have with me Senior Advocate Sridhar Pottaraju. Good to see you again, and looking for some interesting insights. We have Sudhir Mishra, an advocate who's been working on the environment side for more than 2.5 decades. He's the managing partner of Trust Legal, a law firm he founded. Good to see you, Mr. Sudhir Mishra, and looking forward to some interesting insights from you as well. I have with me partner from Saraf and Partners, Manmeet Singh. Manmeet is one of the names in the litigation arena at the Delhi High Court and the Supreme Court, and deals with a lot of litigations of different kinds. He will bring his perspective on the issue. Good to see you, Manmeet. Looking for some interesting insights from you as well. At the outset, may I request Sudhir Mishra, managing partner of law firm Trust Legal, to give a brief introduction, and then we move on to the specifics. Over to you, Mr. Mishra.
Thank you, Tarun. Last 1 week, 10 days have been very exciting for climate litigation across the world, actually. On Sunday, last Sunday, Justice Chandrachud passed this judgment, and this was a judgment which was expected by our country for a long, long time. In 2023 alone, more than 200 climate change litigations have been fought across the world. And while Indian Supreme Court passed this judgment on dated 24th of March, but pronounced just 8 days back, European Court of Human Rights passed an equally important judgment 4 days back. And if you see the repercussion is so huge that the entire solar industry in India, which is impacted by this judgment, where environment has been balanced with environment. So here you have two challenges. Great Indian Bustard is an international union for conservation of nature threatened, highly threatened endangered species, which is very well protected in Indian Wildlife Act. It is in the Schedule 1, Part 1 of the Wildlife Protection Act, where the tiger or elephant is protected. And here you have non-conventional energy, India's commitment to net zero, where we are saying 50% of non-conventional energy by 2030 will be through solar, wind, and hydro. That commitment is also part of an environmental commitment or a climate commitment. So you have to save the Great Indian Bustard. At the same time, you had to also allow the transmission lines to go, which was stopped by the 2021 judgment of the Supreme Court. So it's a very rare case. And the echo of this net zero commitment of India is now even in the political manifesto of every political party in the last 10 days. So the Congress political manifesto, if you see, and the BJP's political manifesto yesterday talks about non-conventional energy being an important source of energy, and the International Solar Alliance, and so on and so forth. You're mute.
Thank you for pointing out. I'll request Manmeet Singh, partner from Saraf and Partners, if you could explain the judgment, then we move on to other specifics with Advocate Sridhar Pottaraju, Senior Advocate. Manmeet, if you could explain the judgment, what are the takeaway from the judgment?
So the judgment arose from a 2021 order made by Supreme Court, in which there was a direction that, to the extent technically feasible, the transmission lines in certain areas of Rajasthan and Gujarat, covering almost 99,000 square kilometers, must be taken underground. Now, that is a significant area of land in two states where majority of renewable projects in India are coming up. And as we know that those are the states with maximum potential, development potential for renewable energy. So obviously an order of this nature has significant implications both on the time and cost implications of development of these projects. And the judgment also applied, the directions also applied to lines which had already been set up. Now, as a result, the implication of this was that projects were getting greatly delayed. There were cost escalations. Solar power developers had moved CERC for seeking cost revisions. And there was a mismatch arising between the PPA and the transmission agreement. Under the transmission agreement, they were liable to make payment of transmission charges because the transmission component had already come up, even though the line connecting the solar power developers project to the transmission component, which was to be set up by the solar power developer, that was not functional on account of this order. So the Ministry of Power, along with MNRE, filed an application seeking variation of the 2021 order, in which they set out the practical technical difficulties in implementing an order of this nature. And some of the reasons which were given were that, it is technically not feasible, the cost is prohibitive, and they also went into the causal relationship why the population of GIB was reducing, and they said it had been reducing since 1960s and it had very little to do with these lines in any event. So in light of this application, Supreme Court had directed the union to file an affidavit taking into account and balancing the interest of both protecting and conserving the GIB, Greater Bustard, as well as making sure that India's international obligations under its various climate change conventions were complied with. And we were not sacrificing those obligations. And while passing this order, Justice Chandrachud has really set out what I would say is one of the, it's a massive development for climate change jurisprudence in India. He has said that we need to look at this, Supreme Court has said that we need to look at this holistically. We have to look at the fact that implications of climate change impact indigenous people, people who are marginalized and do not have the ability to deal with the implications of climate change. And he took into account the fact that if these projects get impacted, renewable energy projects get impacted, then that would need to be offset by coal-based projects, and which would not be in the interest of people more generally. And he read the right to not be impacted by climate change into Article 21 of the Constitution. So I think this is a landmark judgment, and this will lead to more climate change pro orders protecting people from climate change, more of such orders. And essentially, Justice Chandrachud has recalled the previous injunction, and he has directed the settlement of setting up of a committee which will balance the interest of conservation of GIB as well as look into India's treaty commitments and look at whether there can be solutions around putting bird deflectors, specify what can be done to install bird deflectors which are efficacious. And therefore, he has looked at an overall picture. Instead of just looking at the interest of GIB, he has looked at balancing everything out and taking into account that India today needs renewable energy. And these two regions account for a significant chunk of renewable energy. And if we are not able to develop this, then we would have to necessarily offset this with coal. And I think this is a very progressive judgment which has come from Supreme Court.
Thank you for that input. We'll go to Senior Advocate Sridhar Pottaraju. If you could analyze the judgment from the point of view of how the bench, which is Justice Chandrachud, Justice Manoj Mishra, Justice J.B. Pardiwala, how they have balanced the needs of the country's need to grow an energy with the environment, which is the Great Indian Bustard. How tough it is for the Supreme Court when these decisions have to be made, because I think a lot of thinking would go into the kind of implications. So if you could in depth analyze the judgment from that point of view, the Supreme Court balancing ecology and economy both. Ecology, which is essential for India, and economy, which is also essential for India.
I need to really appreciate the great effort put in by the bench presided by the Honorable Chief Justice in actually balancing a very equally important environmental concerns. On one hand, you had the fear of extinction of a Schedule 1 bird, GIB. And on the other hand, we had the Solar Alliance, International Solar Alliance, the commitment to reduce carbon footprint through non-fossil fuel energy, etc., as two sentinel concerns, both actually addressing the Article 21 of the public and the people of the country at large. So these were the competing claims. Normally, we find that it is a competition of rights or claims between commercial, economic, social security of the country on one hand and the environment on the other hand. Here it was environment versus environment in a way. So because on one hand, we had the extinction fears of a bird, which is a Schedule 1 bird. In this, I think the Honorable Court has actually really guided the constitutional principles in a beautiful form. If I may just quote from the judgment, I think the court says it's not a binary choice between conservation and development, but rather a dynamic interplay between protecting a critically endangered species and addressing the pressing global challenge of climate change. I mean, it can't be put more aptly and succinctly, I would say, because the balance that they strike here is trying to bring in a constitutional balance between our commitment to have clean energy and also at the same time not giving up on our concerns under the statutory regime of the Wildlife Protection Act to protect certain species which are on the verge of extinction. So now this is a sentinel statement which has come from the highest court, paving way for the policymakers to understand how the constitutional framework is to be interpreted. And as Sudhir has rightly pointed out, it has been lapped up by the political parties by actually incorporating it in their election manifestos to bring climate change as a serious matter of concern for everyone, to bring it to the voters' attention as such. Here, two things need to be remembered. One, climate change is a broader expression which has now been introduced as a part of your Article 21(14) regime. So what happens now is they are not, I mean, I think this is a watershed moment, as Article 14, 19, and 21 were originally interpreted as independent compartments. But then the interplay was read as a scheme, which actually is the undercurrent which the constitutional framers have brought in. Now, bringing in constitutional status to the right on climate change is, I think, a watershed moment in our constitutional jurisprudence on environment, where they have brought in all aspects, be it environment, be it is water, be it and the wildlife, or probably sustainable development through non-fossil fuels. Because in NCR, we know the problems of fossil fuel-related pollution. So it, I think, is a watershed moment as far as environmental jurisprudence of our country is concerned, where the court has now brought everything under one particular nomenclature called climate change and leading the way forward.
Thank you for analyzing the judgment for us briefly. I'll go to Sudhir Mishra, Managing Partner of Trust Legal. I want to ask you a larger question. Okay, with this judgment now in this close to 1 lakh kilometers, there'll be no overhead cables, which means every cable that is laid down for power will be underground. This is one decision of the Supreme Court. Do you see that our Supreme Court is now progressing on the line where it will now seek to balance our development with our commitment to environment also? Because I think you mentioned to me that in the list of the most polluted cities in the world, India ranks right at the top.
Yeah, Tarun, so this judgment, we all are looking from different angle. Our senior advocate said a very important point. Manmeet also analyzed, gave you the entire sketch, what has happened. For me, there are many takeaways. I would say there is a fashion in the country today to say it's a starter and the main course is going to come. So I will say this Supreme Court judgment is a starter, actually. The main course is going to come after this. How it is a starter? Because this starts where climate right is being told to be a human right. This is a judgment where children who have petitioned in other jurisdictions in the world, their judgment has been cited for the first time. This is a judgment where the Supreme Court says that non-conventional energy has to be promoted because the air pollution problem of India is very acute. So what is going to happen now? Just imagine. 10 years back, projects were being stopped, whether it's a wind power or a hydropower projects, even if they were contributing for climate mitigation. Now, as Manmeet rightly said, that they are saying that the climate right is a very fundamental right now against the adverse impact of environmental damage. Here, what they have done, they have taken into account all the jurisprudence available in the world, and we don't have much jurisprudence as of now. In fact, this judgment, as we speak, is being dissected across the jurisdictions world over now. Now, so you see how it matches with what has happened in last 10 years under Narendra Modi. Last 10 years, you have surpassed every target so far as achieving the non-conventional energy goals are concerned. You have actually surpassed. So if you see, Supreme Court has endorsed the entire climate protocol of international nature, whether it is a Kyoto Protocol they have quoted Paris, they have quoted Glasgow, they have talked about the Paris climate talk, how it led to India and France actually starting Indian Solar Alliance. So if you see the entire net zero strategy of India has been validated in a court of law. It's like we go to a oath commissioner and get the entire document done. Now, entire climate strategy of the country has been validated by the Honorable Supreme Court of India. Now, the future litigations where the climate will move in India would be, there'll be human rights cases if I suffer an environmental wrong. If I have a lung cancer and if I have an air pollution issue, I can also approach the Human Rights Commission. And this should happen after this Supreme Court judgment. Secondly, it has given a huge fillip to the industry, the solar industry in general, because a lot of regulatory clearances, a lot of court litigations and other aspects used to hit them. This entire validation of India's non-conventional energy sources and India being a leader and also understanding that the international commitments, courts have said that the international commitment on climate issues are our guarantee to the world that we are on the right track.
Point well taken. I'll take this to Manmeet Singh, partner from Sarafan Partners. Manmeet, if you specifically look at this case, in the sense, when the Supreme Court takes a decision of this regard, what message is it sending across to the industry at large about development balance with environment, forests, the whole flora and fauna of the country? What is the approach of the court in your view?
So, Tarun, while this judgment is in the context of balancing environment versus environment really, but I think this judgment will set the ball rolling, and I hope the jurisprudence evolves to a point where we see infrastructure availability as a human right and read that as a part of human rights and read that into Article 21. Right? Why should one part of the country have significant infrastructure availability as opposed to other parts of the country? There is a lot of litigation we see to stall infrastructure projects. So, right to have access to roads, to highways, to metro, to ports, because if India has to develop, then its citizens need the kind of infrastructure that allows them to compete with other parts of the world. We live in a globalized world today. We need to have high-speed corridors for facilitating movement of railway goods, for high-speed highways. So a lot of that has to be put in, and a lot of the frivolous litigation which gets instituted to block these kind of projects will have to be tested at the altar of Article 21, in my view, apart from the fact that, look, what are the merits of that litigation? But then you have to balance the competing needs. So even in this case, what the court has done is taken an approach where it has said that we need to have a holistic view. We cannot look at these things in isolation. And I will quote from the judgment that these considerations don't exist in disjunctive silos. I think that's a very important point. So even where litigation may not be entirely frivolous, there may be genuine grievances, genuine concerns, but you have to figure out how to best address those concerns instead of simply saying, let this not happen, let the project not happen. Let the project not happen is a very simplistic approach, but it may not be in the nation's interest. So I think, as Sudhir also said, this is probably only the starters and the main course is yet to come. And we hope as lawyers that this will set the ball rolling for further evolution of jurisprudence on 21.
Point very well taken. I'll go to Senior Advocate Sridhar Pottaraju. If you read the judgment, there are two interesting sections. One is India's right to a healthy environment, which means Justice Chandrachud, who authored this judgment, is very, in a sense, stressing on the fact that we all have a right to healthy environment. And also importance of power and the renewable energy sector. You know, in India, it is become fashionable. A certain set of people are not in this country for extended periods of time on account of health reasons. There's a certain, you know, every country has a certain set of people who can afford to shift to certain locales. But this is a country of 147 crore people. Soon we'll be 160, 170 if population continues at this rate. I mean, so this environment involves all of us. Many of us can't afford to be outside the country. If the environment is bad in those 3 months, so be it. Judges themselves, so many people in the bureaucracy, common people, everybody have to be here. Nobody has the luxury of moving out. So this involves us all. Do you think that finally we've been lax on the NGT space for the past few years? You saw that environment was not really the concern. Do you think that is now coming back? That, okay, you had some major projects to clear, you have cleared them all. Now, at least, environment can't be ignored. From now on, environment development will go hand in hand. It will not be one up against the other. Your analysis on that in view of this judgment?
I always felt that if I may use the Indian expression, dharma sankatam, the decision makers, all the three organs of the Constitution are guided by the directive principles of the Constitution and the constitutional goals which have been defined by the founding fathers of the Constitution. Now, if you look at it from that perspective, each has a very distinct role to play. The executive has enabled the implementation of the policies framed by the legislature, and the Supreme Court especially has, by its interpretation, a robust interpretation of the Constitution as a living document, has made the Constitution live and relevant for times to meet the needs of the times that they are interpreted. Now, in this context, if we look at it, be it the judgment when they have cleared the expansion of the roads in Uttarakhand on an anvil of national security, having consciously being apprised of the infrastructure on the other side of the border. So the constitutional courts are now stepping in as a player which has been constitutionally assigned the responsibility of interpreting the Constitution in a manner to achieve the constitutional goals in sync with the executive and the legislature. So this harmony is possible when there is certainty about the scope of the constitutional provisions and the rights of the people. Now, in this context, if you see, what this judgment has done is it has actually clarified the scope of policy making as well as the legislation future whenever it is made to encompass through a comprehensive legislation governing climate change. Because we have several enactments commencing from the 1972 Wildlife Protection Act, the Water Act, the Air Act, the 86 Environmental Protection Act, to the National Green Tribunals Act. See, we have been addressing these concerns with the times that we lived in. But now, with the experience and the wisdom of hindsight, lived experience and the enhancement of technology and the understanding of the complexities of the issues. Earlier, it was only global warming. Now we move further. We've noticed that it's not only global warming, but also there are areas where the cold has actually increased. The chill effect has increased. So therefore, it is having dynamic implications across the globe. So climate change as a comprehensive description of the right under the Constitution actually would enable and guide the policymakers and the legislature to frame their policies in a manner that it actually furthers the larger constitutional goal of giving a quality life guaranteed under Article 21. Herein, I would like to also draw attention to another Constitution bench judgment in Kaushal Kishore versus State of Uttar Pradesh. The Honorable Supreme Court in this judgment has recognized that Article 19 and 21 are horizontal rights which can be enforced by citizens against citizens, and the courts would entertain writs. So it's a very, very, very important judgment which has empowered the citizen to go to a court of law stating that a private citizen is actually harming the climate or the environment, as the case may be, and violating Article 19 or 21, and it becomes an enforceable right under Article 32. So that constitutional bench judgment, with the backdrop of that judgment, to read this judgment, I see it's a very great movement forward in protecting the environment and our future.
Thank you. Thank you for explaining this. I'll go to Sudhir Mishra for a larger ending question. You've been tracking the environment litigation for the past 25 years, being part of many of the landmark litigations. In that view, could you tell me, first of all, everything has to come from the courts. So things have come to such a pass that the Supreme Court has to issue orders. So your senior advocate Pattaraju couldn't be complaining because he'll get to argue the brief. But things end up at the Supreme Court, and then policy or bureaucracy moves. It takes a lot of time for that to happen, especially on the river front. If we move away, repeated line we read in most articles is that in countries where rivers are not regarded as a mother, rivers are clean. But in countries where river is regarded as a mother, it's in a shape where the whole world takes pictures and shares that our rivers are not in good shape. What do you think is a mindset change India requires? Is that talk less and work more? Or keep on talking and doing nothing, and keep on talking again, just keep on talking again, and then when the matter lands up in court, some action will happen. How would you like to put it?
I will say that I have been part of this for 22 years, and I had the fortune of working with Mr. Pattaraju. He had taken many matters, at least for me, and appearing all over the country on those important matters. I'm just thinking today that how much this country has lost in last 20-25 years on account of agenda litigations, all kind of agenda litigations. I will not tell you specific cases, but you will have the identical case like Great Indian Bustard in Odisha, where there'll be a particular thing and there is some infrastructure project is coming up. And we had this fashion of glorifying everything that it's pitted. Wildlife is against infrastructure or development is against infrastructure. Manmeet also pointed that very important part that, see, as a country, you are the 5th largest economy. You take pride in being the one of the most vibrant middle class, educated middle class. You cannot take different standards now. You also are going voluntarily for net zero, for having a grid which is much more greener. Your methane emissions have to improve in the existing power plants. But ultimately, how you will change all of this? This judgment is a stunner. Why it is a stunner? Because this might stop the agenda-driven litigations now. When you stop a project or you just stop infrastructure on account of something which can be handled. I'm not saying it's not important. So I don't want to be like today, so nobody should feel that like I'm saying this, that a particular species is not important. Species are very important. In fact, if you see the judgment, the court has gone at length explaining how critical it is that we must fulfill this criteria of protecting the Great Indian Bustard. But I believe the mindset thing has not changed. You still find people at Yamuna Bridge when you come from Noida. And sometime even I have got out of my car and stopped them. Those costly cars, they come out of it, bring their plastic where they have something kept there. They climb on the rails where it is written, it's your river, it's your mother, please don't pollute it. Still, I will climb the rails, I will put the plastic inside the river. What will the Supreme Court do under those circumstances? So our challenges are much deeper, but yes, so far as our being a trendsetter, as a representative of the 5th largest economy, our place under the sun, I think this judgment, which revolves around the sun, is a path-breaking judgment.
Thank you. But we'll take 2 quick 30-second inputs, Manmeet Singh, Saraf and partners. I want to ask you, Manmeet, 2 things. Especially, we saw some water-based protests in Bangalore and how badly it has been handled. Do you think that birds the Supreme Court has handled, but I think the most difficult one to handle will be water in the coming few months or years? Water is going to be not Bangalore, it could be many other cities soon. Bangalore, because obviously it's bursting at its seams with migrant population.
Oh, absolutely. I was reading a news report the other day done by one of the popular search platforms that the searches for water and water services related water providers has really multiplied in Bangalore and Hyderabad. So you're absolutely right. I think the greatest climate change related issue that India faces today, apart from, of course, increases in temperature, is water scarcity. And there, I think the government will also have to do a lot more at the policy level to ensure that a lot of the conservation measures are put in place that we are able to address this concern. Otherwise, Indian cities will be reduced to being deserts, and obviously.
One final comment from Senior Advocate Sridhar Pottaraju. You had the people protesting against the state government in Bangalore and water. They're still not getting it. So the situation is so bad that 30-year loans on flats. Flats are costing crores. EMI is getting cut from salary, and there is no water in the house. Not that a situation you can't run away from. The state government or the central government can't build a dam overnight. It takes 20 years in India to build a dam, or at least 10, 12 years. Do you think that these are questions to which even the court will find it difficult to find answers? This is a difficult problem India has now.
I think courts are not panacea for all the problems the society or the country faces. I think we should be clear on that. Courts are stretched with their primary responsibilities of adjudication of disputes, but they still take time out and put a lot of effort to give certainty to the law of the land, the constitutional framework, and the rights of the citizens. Now, in this context, if we see, the problem is with reference to the pigeonhole approach of issues. I think we need to have a holistic understanding of the nature of the problem and also have holistic solutions. So therefore, this description of climate change as a fundamental right is a game changer. Therefore, I said it is a watershed moment, because now we can't look at water problem in isolation from your underground water table being depleted by rampant borewell pumps used for construction industry. See, these are very much interconnected. And then urbanization and non-development in rural areas is also a reason for migration. So these are all interconnected challenges, and I think the people in power would address it. On this issue, I just happened to recall something from Mahabharata. Extinction of a species is nothing new. You will find a reference to that in the Vanaparva. The Pandavas have been staying in the forest for a very long time. And there, in the subchapter referred to as Mriga Sapno Bhava Parva, the deer come in this dream of Yudhishthira. And then they say that you've already extincted more or less the species. Now the people, the deer which are alive, which have come to plead with you, are remaining seed of our species. And if you continue to hunt us here, then we'll be extinct. So therefore, please protect us. And then the next day morning, Yudhishthira gets up, and then his conscience is stirred. And he says that it's time that we move on. On this note, you look at the lifestyle of the Gujars in Rajaji National Park. They do a migratory lopping lifestyle. They move to the hills during the summers and come down during winters, enabling the vegetation to recoup and rehabilitate. So therefore, traditionally, India has always understood the interlink or the balance of the ecology with all species having equal stake. The flora-fauna judgment of the Supreme Court also actually recognizes this principle. I think if we educate ourselves with our own literature and understand the holistic life, which has to be understood in a comprehensive manner and not a pigeonhole manner, I think there probably the country and the people would be better off as against what we were earlier.
On a lighter note, I would like to end the show by saying that in Delhi also there is a set of people in law who move to the hills during summers and come back during winter.
Well, I think for Delhi, I have one more thing to say. They keep complaining about air pollution. And then you look at the dinners that we have in Delhi. The winter dinners, you have live kebab counters across discussing air pollution. I mean, that's the irony of Delhi. And then if you look at the negative impact of livestock on food plates is a direct contribution that we as an individual make towards making our pollution problem more enormous. I think
now you are entering into difficult areas.
No, I know this is an area where it is individual discretion and individual contribution. It's not always about rights. We are a society, culture, as a civilization, we are driven by our duties. So we need to be conscious that do we need to have this kind of a food every meal, or can we defer it? as our
Point
part
well
of
taken.
conversation.
I presume my two co-panelists would not entirely agree, but this gastronomical debate is for another show, which we'll surely get to do. Thank you so much for joining in. Today was an interesting show, and I would recommend all viewers to read this judgment, ably authored by Justice Chandrachud, and the bench was Justice Chandrachud, Justice Partiwala, and Justice Manoj Mishra. I appreciate you joining us. Thank you so very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.